Hello again. We're now in chapter 3 of our book. This one's on genetics and genomics. There are 3 sections to this chapter. Today, we'll see how far we can get through. Well, there'll be 4 lectures out of this section, Genetics and Society. We're going to start with Paul Lombardo's essay, Medicine, Eugenics, and the Supreme Court from Coercive Sterilization to Reproductive Freedom. So we begin with eugenics, which is clearly the least technologically sophisticated mode of genetic intervention, being basically selective breeding, but it's been the most socially, has had the most social consequences from early in the 20th century. It's much older than that, of course. Let's talk about eugenics first before we get to Lombardo. How about this? Here's a quote. See if you have any idea who might have said this. I wish very much that the wrong people could be prevented entirely from breeding. And when the evil nature of these people is sufficiently flagrant, this should be done. Criminals should be sterilized, and feeble-minded persons forbidden to leave offspring behind them. The emphasis should be laid on getting desirable people to breed. Any idea? It's not Hitler. It's Theodore Roosevelt, our 26th president. So eugenics was interestingly supported by both conservatives and progressives in the early part of the 20th century, for obviously different reasons. It goes much farther back than that, of course. Plato, selective breeding, was discussed or used by Plato in his Republic. It becomes state coercion using eugenics becomes part of its meaning in the 20th century. Our introduction to this part of the book mentions Francis Galton, who was a cousin of Charles Darwin. It's really Galton who gave us the label eugenics and was an advocate of positive eugenics. We'll make that distinction soon. The reason why progressives were interested in eugenics is that the great enthusiasm with Mendelian genetics in the 19th century, and the possibility that genetics held out for solving all kinds of social problems. Conservatives were interested in this for the same reasons, actually, that believing that feeble-mindedness, as it was called at the time, was a cause of social problems, criminality, largely. So there is a connection with progressivism. It's connected, obviously, with racial concerns. There's contemporary concern regarding the disproportionate birth rates among various ethnic communities that can be affected by through eugenic principles. We need to make a distinction between positive and negative eugenics. I mentioned Galton in connection with positive eugenics. Negative eugenics is the idea of discouraging, to put it mildly, people with undesirable people, meaning people who have traits that were supposedly determined genetically, to prevent them from reproducing. Positive eugenics would be in the encouragement of people with desirable traits to reproduce. There was in early part of the 20th century in the state of Kansas, the Kansas Free Fair, which was their state fair, would have fitter family competitions so that couples could appear with their child or children and get designations like grade A, like cattle or something, for being superior genetic stock of the state. Eugenic sterilization laws appeared in about 24 states by the late 20s. This is involuntary sterilization for the purpose of preventing the propagation of supposedly bad traits in society that are genetically linked. the practice didn't extend, in fact, beyond institutionalized populations. And so it fell disproportionately upon poor people and minorities. Sterilization in some societies in Europe, particularly among social democracies in Scandinavia, became part of economic policy. It's thought of, so if you're a welfare state and a great part of your poor are poor generationally, generations of the same family being poor, it was thought to be the right thing to do for society's sake to prevent these families from having more children. Eugenics was increasingly criticized during the interwar years. There were always reservations about it, but it continued into the 1970s in some states. There's a history of it in Wisconsin. There are 1,823 people on record who were sterilized involuntarily in Wisconsin institutions. A law was passed in 1913 that would enable this. Involuntary sterilization began in 1915. The numbers of those sterilized increased in the 1930s, remaining high until the end of World War II. It's about 80 per year, or about 3 per 100,000 in the population. The motivation was originally the economic crises of the 1890s. Again, it targeted the so-called feeble-minded because of the risk of their reproducing. In 1907, Wisconsin made it illegal for epileptics, the feeble-minded, and the insane to marry. It became a misdemeanor for those people to have sexual intercourse. In 1955, epileptics were eliminated from the sterilization law. Also, the law was changed so that others could marry if they were sterilized. Charles Van Hise, president who lived between 1857 and 1918, was a president of the University of Wisconsin. The tallest building on campus in Madison is Van Hise Hall, named after him. He promoted eugenic thought by founding the UW School of Criminology. The Home for the Feeble-Minded and the Wisconsin Hospital for the Insane were the two largest institutions that did involuntary sterilization in Wisconsin. So we certainly have our own history here of this, and many other states do as well. Lombardo is a law professor, and he focuses on Supreme Court decisions. What he wants to do is to make the connection between our eugenic history as reflected in Supreme Court decisions and contemporary ethical and policy issues, including criminology and reproductive policy and migration policy. He makes those connections at the end. So this begins in our text on page 142. So he mentions eugenics as the hope for the gradual improvement of the human race with the simultaneous elimination of social ills. That was eugenics' aim. He mentions the distinction between positive and negative eugenics, as we did. Presidents from Theodore Roosevelt to Herbert Hoover were enthusiasts and advocates of eugenics. Most eugenic policy was effected through law between 1900 and 1970. There were nearly 100 statutes that were enacted by state legislatures, mostly limiting the reproductive rights of some people. Lombardo focuses on 3 cases. He argues that, again, the current language of reproductive rights, including Roe v. Wade, can be traced to eugenic cases. Harry Laughlin was a eugenics activist in the early part of the 20th century. His 3 principles of eugenics include these. First, social, moral, physical, and mental qualities are transmitted in predictable ways by mechanisms of heredity. Second, the human race can be improved by selective breeding. And third, the ills of society, including disease, crime, poverty, and so on, can be eradicated by discouraging or preventing the reproduction of certain individuals. Success, Lombardo says, was achieved by implementing eugenic policy as public health initiatives. The three eugenics cases which reached the Supreme Court are typified by the involvement of physicians. This is pretty disturbing. We see this in the US, but in other countries as well. Think of the Holocaust and the language used, and in fact the chemical agent used for extermination of people in the concentration camps. It was a pesticide. So being a Jew was understood to be a disease on society. And they took the metaphor and they made it real. This was advocated by physicians using science, pseudoscience, as the basis for public health, so-called public health policy. And so the Nazis, of course, this happened in Rwanda during their genocide. It's really disturbing. It's not just medicine. Law, also, various professions get behind these ideological bases for genocidal policies. There was strong support, Lombardo says, for surgical sterilization as a public health intervention. He says it was far from mainstream in either the law or in medicine. Forced sterilization was an extraordinarily radical departure from existing Supreme Court medical jurisprudence. The Supreme Court had previously forbidden even court-ordered medical examination. With the exception of vaccination for contagious diseases, no court-ordered medical procedures had been endorsed by the Supreme Court prior to Buck versus Bell. But Buck also did not change the court's general attitude toward coercive medical intervention. You know, in Buck versus Bell, and Lombardo actually went to the institution where Carrie Buck was institutionalized and found she supposedly was feeble-minded. Again, her mother was supposedly feeble-minded, and she had a feeble-minded child. Chief Justice Holmes famously and chillingly said, 3 generations of imbeciles are enough. Lombardo found when he went to visit her that she was doing crossword puzzles with a friend. She was a woman of normal intelligence. So why was she there? Well, she had been, I think she had foster parents and had been sexually molested and made pregnant. And as was the custom of the time, she was sent away to have her baby somewhere else so as not to bring shame upon the family, and hence was institutionalized. So Buck versus Bell as supported the Virginia decision, supported by the Supreme Court, was an exception to the policy up to then of the Supreme Court, not even to allow court-ordered physical examination, says battery, but just the forced surgical sterilization was something that they saw as allowable this time. All right, so he asks, if Buck is such an exception, how did it happen? He argues that it's because of the public health connection, again. And we'll get a quote from Holmes. He says, it's better for all the world if instead of waiting to execute degenerate offspring for crime or to let them starve for their imbecility, society can prevent those who are manifestly unfit from continuing their kind. Jacobson versus Massachusetts was a decision upholding a statute compelling vaccination against smallpox. This was the only precedent that Holmes had cited. Following the Supreme Court's endorsement of sterilization in Buck versus Bell, over 30 states eventually passed sterilization laws. The next case is Skinner versus Oklahoma. Oklahoma passed a sterilization law in 1931. Samuel Maine, a resident of the Central Oklahoma State Hospital at Norman, was diagnosed as manic depressive and had a father who also had spent time in mental institutions. Maine had 4 children and a pregnant wife. He was the first of 556 Oklahomans to be sterilized under the law. The test case for the law was of Jack Skinner. Skinner was a 3-time felon. He had showed no evidence of hereditary criminality. The defense's contrary evidence was ruled inadmissible, the only relevant question being whether Skinner was a 3-time felon guilty of crimes of moral turpitude. So there's some chance that this was genetically based, then it was good for society that he be sterilized. The Supreme Court reviewed the Oklahoma law. Justice Douglas wrote the opinion, which says, this case touches a sensitive and important area of human rights. Oklahoma deprives certain individuals of a right which is basic to the perpetuation of a race, the right to have offspring. He later says, we're dealing here with legislation which involves one of the basic civil rights of man. Marriage and procreation are fundamental to the very existence and survival of the race. Lombardo says this is the first time the Supreme Court described reproductive prerogatives as fundamental rights. Douglas's notes, personal notes, suggested that he made a clear distinction between Buck and Skinner. He was willing to allow the possible scientific legitimacy of Buck, but not of Skinner. Next case is Loving versus Virginia. You may remember this. There was a film out a couple of years ago called Loving about this case. In Loving versus Commonwealth, the trial judge issued a written opinion which, in its simplicity, Lombardo says, remains a monument to bigotry, masquerading as both science and religion. First off, what's the case about? In 1958, a grand jury issued an indictment charging Mildred Jeter, a black woman, and Richard Lovett, who was white, with violating the Virginia ban on interracial marriage. They'd been married in 1958 in the District of Columbia and moved to Virginia soon after that. The couple pleaded guilty to the charge of interracial marriage and were sentenced to 1 year in jail. However, the trial judge suspended the sentence on the condition that they leave the state and not return together. The period of exile was to last 25 years. So, and then the trial judges remarked here that Lombardo quotes, Almighty God created the races white, black, yellow, Malay, and red, and he placed them on separate continents. And but for the interference with this arrangement, there would be no cause for such marriages. The fact that he separated the races shows that he did not intend for the races to mix. Justice Berger, in the opinion on Loving versus Virginia, says, marriage is one of the basic civil rights of man, fundamental to our very existence and survival. The 14th Amendment requires that the freedom of choice to marry not be restricted by invidious racial discriminations. Under our Constitution, the freedom to marry or not marry a person of another race resides with the individual and cannot be infringed by the state. In Griswold versus Connecticut, which struck down laws prohibiting the distribution of birth control devices and information, introduced the idea of a fundamental right to privacy that protected other constitutional rights. Griswold relied on Skinner to hold that marriage and procreation were fundamental rights. In Roe v. Wade, the right to an abortion was explained and qualified by all 3 of the Eugenics decisions. Citing both Loving and Skinner, the court noted that the right to privacy extended to marriage and procreation, but it also recalled the past decisions such as Buck, that they clarified that there is not an unlimited right to do with one's body as one pleases. Buck supported the arguments that government could place limitations on a woman's reproductive decisions, and opening allowing states to regulate abortions in later stages of fetal development. Skinner and Loving repudiated eugenics statutes. Buck upheld one. All 3 have contributed, Lombardo says, to the understanding of reproductive rights as a constitutional issue. Skinner qualified but did not overrule Buck. Skinner generated the rights language foundational for Griswold. Privacy right in Griswold was qualified in Loving and ultimately adopted in Roe v. Wade. The ideas of the eugenicists are reflected, Lombardo says, in current controversies. Do the mentally ill or the developmentally disabled have rights equivalent to the general population with respect to reproduction and elsewhere in civic life? What roles does low IQ or other inherited characteristics play in determining a future criminal career? And how does the ethnic composition of society affect its health? He concludes the eugenicists attempted to answer these questions wrongly each time, but they had an effect in the record of legislation through most of the 20th century. Today, we're in the midst of debates on immigration, inherited intelligence, and links between ethnicity and crime. The legal successes of the eugenicists should give us pause. So, our next essay will be by Sparrow.